Hi, everyone. So today we are going to be doing some Q&A. So send me your comments, send me your questions in the comments. And we are going to be talking about some new immigration things because the advice I gave last week is no longer the advice this week. So we're going to cover that as well. Send your questions in the comments. If you are joining me live, say hi. Tell me where you're joining me from. First thing first, okay? I had someone ask me a question last week about the registration requirement from the Trump administration and whether applying for parole and having done biometrics is enough to meet the requirements for the registration. And as of last week, based on what the administration was saying, that seemed like it was enough, right? That it met the requirements. However, new week, new information, right? So for the registration requirement, if you have not registered, there is things you need to do. Okay. So if you have not registered and you have a registration requirement, so you have to start there. Do you actually have a registration requirement? Right. That's number one. And if you do have a registration requirement, have you met that requirement? So anyone that's not a US citizen that's in the US more than 30 days has a registration requirement. Okay. If you're not a US citizen and you've been physically in the US for more than 30 days, you have a registration requirement. Now, if you are a permanent resident, if you came to the US with a visa, if you have ever applied for a visa, like there's so many things. If you've ever gotten a work permit, so applying for a work permit is one thing, but actually having it approved is what gets you the registration. So they are saying for the registration, you need something that shows that you have registered, right? That you have met all the requirements of the registration. Unfortunately, having an application pending on its own may not be enough to meet that requirement. So you definitely want to speak with an immigration lawyer and see if you actually have a registration requirement. And if you do, have you satisfied it? Okay. If you're a permanent resident and you're watching this, you don't need to register. You're already registered. Okay. You are a permanent resident. If you have a work permit, you are already registered. If you have a green card application pending, an I-485 pending, you already met the registration requirements. Okay. Because again, USCIS is very specific and has given us more guidance on what that registration requirement looks like and what they're actually looking for when it comes to registration. I am doing a video on Tuesday where I'm going to break down the registration requirement in more detail, but I know that someone asked me that question last week, and because the answer to it has changed, I wanted to take the time and cover that at the beginning. So if you apply for parole under the Biden administration parole program and you the parole in place for spouses of US citizens, that one specifically, that's what the person was asking about. If you apply for that specific parole and you were not approved, right, because the parole program ended, um, even though you did your biometrics, you may still not be considered as registered. Okay. But if you are in immigration court, right, if you've ever been in immigration court, you had the notice to appear, those qualify you as registered. So there's a lot of people that are nervous about registration, but a lot of you out there are already registered. You just don't know it, right? You don't know it counts as registration. So if you are not sure if you're registered or not, definitely reach out to an immigration lawyer, find out if what you have done counts as registration, and then go from there. Okay. Um, Jay, hi, how are you? This is a live video. So Jay was asking on YouTube if this is a live video or if it's a premiere. This is a live video. So ask me questions because I want to. But that's a great question though, because sometimes it can be confusing. If I ever do a premiere on a Friday, um, it's going to be very obvious because I'm going to tell you that it's a premiere. Okay. Um, so just know that. But if it's live, it's live. But if it's a premiere, I will let you know so you're not confused when you ask questions and no one sees, I'm not responding to it. Just know it's live, ask questions. Okay. So that's the first thing I wanted to cover because that's something that the registration stuff is something that is new this year as far as the administration's um, enforcement of it, right? So it's always been a thing to register. It's always been a thing. It's just how each administration chooses to enforce the immigration laws that are in place is what's really the difference with this particular administration. They are literally finding all the little things that they can find and that they can use against immigrants and using it. Okay. Those things were already there. They're just using it differently or putting more emphasis on some things. Okay. So don't be scared. If you have a requirement, you need to decide whether to register or not. If you have a green card application pending, if you are already in immigration court or have ever been in immigration court, you are already registered. Okay. So just know that. All right. So if you have questions, put them in the comments. I did a Q&A last week, and a lot of it was live questions. And I did get people that asked me questions ahead of time, and I want to cover those as well. So these are questions people sent me. This may be important for you to have answers to, okay? Because a lot of you out there are scared, are not sure what's going on. And a lot of the questions that I have been getting over and over and over is whether cases are still being approved, is immigration still working, right? Is immigration still working? So here is the breakdown. Immigration is still working, right? People are still being approved. Applications are still being processed. This week alone, we got 2 work permits into the office. So applications are still being processed and applications are still being approved. The only the only cases that are not being approved right now are applications like green card applications where the person came in through one of the Biden parole programs, or if the person is an asylee or a refugee, those green card applications are on hold. Okay. So USCIS may process them, but they cannot approve them until the pause is over. So those are the only applications that are not going all the way through to approval. Okay. So it starts with filing the application, USCIS processes it, decides if they're going to set up an interview, and then make a decision on the case, right? They can do everything up to making that decision. So if you have a green card application pending and you entered either for through U4U parole or the parole that was done for certain countries, if you entered the US with one of those, just know there's going to be a pause. Okay, there's going to be a pause in the approval, but you may still get an interview notice. Okay, they may still continue processing the application. That's really important because a lot of people think that they shouldn't be filing applications because the new administration is in. If you qualify, so this is what I go through with my clients before we file any application. We look at if they qualify, right? If they have anything negative in their history, criminal, immigration, anything like that, that will need a waiver or that will make them inadmissible or deportable. We look at that first and make a decision of, okay, this does not make you deportable or inadmissible. Or if it makes you inadmissible, there's a waiver that you qualify for. So we make all that decision on the front end before we even file the application. So even though people are scared to file, there are steps that you can take to make sure that you are giving yourself the best possible scenario when you file. Okay. And that's making sure that you are not putting yourself in deportation proceedings. And I have seen this happen, okay, where people file their application. They didn't think that, that one crime from 20 years ago would be a problem. And then it turned out that that was a drug related offense, and there's no waiver for a drug related offense unless it's less than 30 grams of marijuana for personal use, right? Unless it's that, there's no waiver for it. And now they're applying for a green card. It comes up, they're inadmissible, but they're also deportable because it's a crime involving narcotics. Like the US government does not want you um, you know, using anything, right? They don't want you using any drugs, but especially things that are not like marijuana for personal use, that's less than 30 grams. Again, that is the only waiver. That's the only one that has a waiver. So it's really important that we know that. And before you file, that you have already reviewed your records and know that nothing in your records will actually be a problem for you. So if you have done all of that and you know that none of that is going to lead to deportation proceedings on its own, then and you qualify for the thing you're filing for. Okay, that's the second part. Not only do you meet, you don't have any of those negative things, but you qualify for the thing that you're applying for. So, for example, if you're filing for a marriage based petition, can you prove to USCIS that this marriage is real? Right? Do you have documentation to show that? Are you prepared to have an interview where you will have to prove to an officer that your marriage is real? Those are the things you need to think about on the front end. And once you know that you don't have anything negative in your records, your marriage is real, you can prove it, you're ready to go, you can apply, right? You don't have to, let this administration stop you from applying. Okay. But you have to do the front end work before you put in that application because again, if it gets denied, you may end up in deportation proceedings because of the new NTA memo. So that's why I say that front end work of making sure you qualify, making sure you don't have any criminal history that will be an issue, you don't have any negative immigration history that will be an issue. You want to get all of that done first before you file because the consequences now of a denial is worse than it was a year ago. What am I talking about? It's worse than it was like 3 months ago. Okay. So definitely want to keep all of that in mind before you file. All right. So peace on earth. If your green card application is approved along with a 601 waiver for a crime that is also deportable, but not an aggravated felony, does the waiver apply for both? So a 601 waiver for inadmissibility does not typically also apply to deportability. Okay. But it is up to USCIS. Again, it depends. If you already have the green card, it would be up to ICE or USCIS, depending on if you're applying for naturalization, to decide whether to issue a notice to appear. In these situations, they're typically not issuing a notice to appear, and you may want to. And if there was a waiver for the inadmissibility, there may be a waiver for the deportability aspect of it as well. Okay, so sometimes there is, if you can waive the inadmissibility, you may also be able to waive the deportability part of it. Um, just a guy, not answering your question. Like if anyone knows, like if you have watched my videos, you know that my husband and I, right? So that's how I answer that question. Um, Quick background. I'm a 10 years green card holder. Great. I was a victim of a crime. Not so great. Three drug dealers attacked me. I defend myself. But when I called the cops, they came, they arrested me. The judge granted me a program where I don't have to do anything, just stay out of trouble, and the case will be dismissed. I know it's not a conviction. How can I go about that on naturalization? So, based on what you're telling me, I do not know that it's not a conviction. Okay, so some things in criminal court may not be a conviction. However, immigration may see it differently. So it really depends on your particular situation, right? It depends on what's on the records for the court. So even though you got probation, which is what it sounds like, if it's like pre-trial probation where there's no admission of guilt in any way, then that's not a conviction for immigration purposes, and typically you would be able to apply for naturalization. I typically also recommend, depending on what's on the criminal complaint and everything, to maybe wait 5 years from the date of the incident before applying for naturalization, or 3 years, depending on if you are married to a US citizen. Okay. Um, but it will depend on the details. If it is a straight up dismissal where the court is just like, we're throwing this out, okay? We are throwing this out. Then in that case, it would not be a conviction, right? For immigration purposes. So if it was just thrown out and there's no probation, then you probably may be able to apply for naturalization and it wouldn't be a problem. But if there was probation, so for other people, right, if you had a court case that is not a problem for immigration purposes, but you are still on probation, do not apply for naturalization. It will not be approved. Okay, because they do not know if you are going to violate your probation before it ends. So unless you have the documentation showing that your probation is completed and it was done successfully, the officer will not be able to actually approve your naturalization. So if you are currently on probation and you want to apply, don't do it. Okay, wait till you have successfully completed the probation, and also make sure that the crime does not make you deportable or inadmissible. All right, do that first, but also see if you need to wait the 5 years or if you are able to apply right away. Okay. With this new administration, do you think applying for citizenship will be a smooth process? It depends on the background, right? Nationalization is kind of the last step to being done with US immigration. Okay. So when it comes to that, they will look at your entire history, your entire history. So it's not as if it's not going to be a smooth process. So if someone entered the US, got their green card, never had any criminal history, never had any immigration issues, apply for citizenship, it's probably going to be smooth for them. But if the person has ever had any criminal history, with this administration, they are going to be looking at those deeper than previous administrations. So before, it's like, if you meet the requirements and this crime does not make you inadmissible or deportable, my advice was go ahead and file. But with this administration, you really want to be careful. You really want to have all your ducks in a row before you go ahead and file. But yeah, just a guy. It's okay. You're not the first person to ask. And I am always happy to do these free online sessions because it makes such a difference. And I do see people that were watching my videos 2 years ago or a year ago coming back and telling me how they now have their green card or now they've gotten their citizenship. Like, that's why I am here. It's the community. You guys are amazing. You guys ask amazing questions, and if I can help even one person with a video. Um, I am grateful. All right. All right. So this question came in. Does an I-751 divorce case always require an interview before they take a decision or deny the case? Does it always require an interview? Not always, right? But I have not seen them deny it without an interview. Okay. They can, right? They can make a decision on a case without ever doing an interview. However, typically in an I-751 case, in an I-130 case, in a green card application case, we have seen that USCIS will schedule an interview if the answer is not a yes, right? So if they want to deny it, they will send you a notice of intent to deny, um, or a request for evidence because they want more information before they make that final decision. So if they send you a notice of intent to deny or they send you a request for evidence, please take it seriously. Okay, because that is your opportunity to find out what is the issue in the case and how can you present it in a way that will make USCIS understand that, if it's in this case an I-751 removal of conditions based on divorce, you want to still be able to make sure they have all the things they need to see that that marriage was real. Okay, just because it ended in divorce does not mean the marriage was not real to start with. So you want to have that documentation to show that. And when you get that request for evidence, you want to really give them as much as you possibly can. And then they'll make a decision on whether to schedule you for an interview or go ahead and approve the case without an interview. I will tell you that within, in the Trump administration, I have gotten an approval for a case we filed, an I-751. It was not based on divorce, it was based on abuse, and it was approved without an interview. Okay. Again, this was on the early end of the Trump administration. We're only like 3 months in, but it was like a month and a half into the administration that we got that approval. So they may still approve those cases without an interview. But if you have a green card application based on family, marriage, parents, children, just know you are 9 times out of 10 going to get an interview. Okay. Just be prepared for it. They are looking to go full interview for all of those family based cases. So please be ready for that in case it does happen. All right. Mm, um, oh, great question. Yes, yes, we do we do VAWA. Um, those are one of my passion cases because it makes such a difference in people's lives and helps people get out of abusive relationships. Um, so yes, we definitely do VAWA cases. All right. So just want to make sure I am not missing any questions from anyone live. Remember, if you are joining me live and you have a question, put them in the comments. And if you are watching and you are looking to so if you are looking to schedule a consultation with me, a strategy session, my strategy sessions are 15 minutes. They're free. You come in, we talk about your situation and see if there's something we can do, if there's steps that you need to take. And then with the consultation, you can send me documents ahead of time. We can do a deep dive into your situation and come up with solutions for you. Okay. So you can do either of those things by going to my website. Okay. So I'm just putting that on the bottom. Ask me questions. Okay. But you can also schedule them. I was denied 28 years ago. Can I reapply for citizenship? I never got arrested. So it depends. Can you reapply? Yes. However, before you do that, you need to know exactly why you were denied the first time around. Okay. You need to know that because depending on the reason, you may be able to just reapply and go through the process and be okay. But depending on the reason, it may not be a good idea to reapply. Okay. So you want to start with what was the exact reason you were denied, and can you overcome that reason? If we feel, again, this is what I go through with my clients, right? We have to go through, and that's where the consultations come in, right? We have to go through that denial notice. If you don't have it, we need to get it. And if you're not able to get it, we'll do a Freedom of Information Act request to help you get it. And we would review that denial notice, find out exactly why you were denied. And then from there, we are now able to figure out, okay, based on the reason you were denied, is this something that can be overcome? Do we have documentation to show that you now meet the requirements, and you're not going to get denied for that same reason? And then with that, we can take the next steps of, yes, you can go ahead and apply, or no, it may not be a good idea for you to reapply, right? So that's the analysis you will want to do there. But it really all comes down to why you were denied, and are you able to overcome that reason? Hi, Kelly. What's the process if you're married and filing for your spouse, but you accidentally file single on your taxes? What's the next step with correcting that? And how can that delay your documents? Um, Okay. So there's two ways of looking at this. If your spouse is in the US versus if your spouse is not in the US. Okay. If your spouse is in the US, you can get them an I-10 and amend your tax return. That's the solution, regardless. If you want to change the single to married filing separately, married filing jointly, whatever you want to change it to, because those are the two you can do, is either married filing jointly or married filing separately. So if you're doing married filing separately, you can go ahead and amend your tax return for the years that you need to amend it. Okay. If your spouse is physically in the US, they can get an I-10, and you can use that to amend your tax return. And I have had clients do this. So that's why that's why I'm mentioning that. If your spouse is not in the US, you need to talk to an accountant or a tax professional to see if that single status is actually allowed, right? Because sometimes I've, I will say this, I've had clients where they did the single status and it was not a problem because their spouse is not in the US. But with this administration, we are being extra special careful with every single person, right? Every single petition, we are being also careful because we want to make sure that not, those little things are not going to lead to a denial. So you want to make sure that you amend, right? If you have to, go ahead and amend your tax return. That's what you'll have to do. As far as will I delay your documents, you can file your typically if you're amending, you'll get that right away. So work with a tax professional. Okay. You need to work with a tax professional. And if your spouse that's in the US does not have a social, or they don't have a tax ID number, you can work with a IRS acceptance agent, because then they can do the amendment and do the I-10 for you all at the same time. So again, if they don't have a social and they don't already have an I-10, you need to work with a IRS acceptance agent, because that will be your fastest way of getting it done. Okay. And once you get it done, typically they can get it done within a week. So depending on, tax season just ended, so things may be slowing down for them. So you may be able to get it done faster, but it shouldn't really slow your process down too much. If you already started the filing process, um, if you have an interview, just take the amended one to the interview and explain to the officer why you had to amend, right? It's okay. It's not. So basically, the reason you want to amend, because your spouse is in the US, is that you don't want anything to make USCIS think that you are not putting yourself out there as a married person. So that's the consequence, right? If the USCIS officer is looking at your forms and they're looking at your supporting evidence and they see your tax return, and instead of saying married filing jointly or married filing separately, it says single. That means you are presenting yourself to the US government, to the IRS as single, but you are at USCIS presenting yourself as married. So now the officer is like, are you lying to the IRS or are you lying to USCIS? Right? Which one is it? So to remove all of that, my recommendation to every single client that comes through my door when we are filing their green card application in the US, we always look at the tax return and make sure that they are filing either jointly or separately, but not single. Okay. And not head of household. Because I have learned from my accountant friends that the only way that you can file head of household is if you did not live with your spouse the last 6 months of the year. And if you're telling USCIS that you and your spouse have been living together, building a life together, but then your tax return is telling the IRS that you two have not lived together the last 6 months of the year, you see how that would be a problem, right? You see how that may be a problem. So we really want to, just make sure that every single thing that you're sending to USCIS gives a consistent story, right? A consistent narrative. If you're married, you are showing that you're married. And everything you're sending to USCIS is showing that you're married. Okay? All right. All right. Great questions, guys. Remember, keep asking them. All right. So this question came in, and I'm like, I need to cover this because people always have this misconception about the 601A and 601 waivers. So, what if hardship for yourself, right? For a 601A waiver or a 601 waiver, you need to show hardship to a US citizen or permanent resident spouse or parent. Those are your only options. Spouse, parent, one of them, both of them, as long as they're US citizen or a permanent resident, you need to show extreme hardship to them. And this person is asking, what about hardship for yourself? Since you already situated in the US, removing you will cause emotional hardship and financial hardship. Here's the thing. The US government does not care about hardship to you. They care about hardship to US citizens and hardships to permanent residents. The only time they care about hardship to the person asking for the waiver is if the person is applying for a green card based on VAWA. Yeah, that's where they really care. Or if the person is an asylee or a refugee applying for a waiver, they can use themselves as the qualifying relative for the waiver. But beyond that, right? Beyond that, you need to have a US citizen, spouse, or parent. And I have my I have people that come to me and they have been in the US forever. Their children are now 21. They want to file for them, but they have a misrepresentation in the past, or they have a criminal case that can be waived, but you need a qualifying relative for, right? Or they entered the US without inspection. Now they have a child that's over 21, willing to file for them, but they don't have a qualifying relative for the 601A waiver. When they're in that situation, I feel horrible because now I have to tell them that they can't actually move forward with getting the green card, with getting the visa because they don't have a qualifying relative. However, if it's a VAWA case, if it is a VAWA case, you can use yourself. So if you file for VAWA, your VAWA is approved, and now you're waiting on your green card. USCIS says, hey, there's misrepresentation here. You can use yourself as the qualifying person for that 601 waiver. You still need to show extreme hardship, Okay, you still need to show that, but you can use yourself. And just because you've been in the US for 20 years, it's not enough to get the waiver. Okay, because what makes you different from every other person that's been in the US for 20 years? Right? Yes, you are used to life in the US, but how would you having to leave the US cause you extreme hardship other than the fact that you have gotten comfortable in the US? That's where the emotional hardship, the financial hardship, the medical hardships come in. Okay. Just a guy. Well, if you lie on your tax return, that's an issue of its own too. Yes, it is. And that's where the amendment comes in. You don't want the IRS to be the ones to flag that for you. You want to let them know that there's an issue and fix that. Okay. I have this problem. Oh, no. I have this problem on about the tax filing. Yes. A lot of people have this problem around tax time. I know tax deadline just passed on the 15th. So just know you need to be sure that when you're filing your tax returns, you are not just listening to your preparer, you are paying attention to the fact that you're going to be filing for a spouse in the future, right? You're going to be filing for your spouse. You know that your tax return is part of the evidence that needs to go into that packet. So you need to make sure that even if your tax preparer tells you, oh yeah, you can just file single since they don't have a social. We get that a lot. I get that a lot where the tax preparer will actually tell the person, oh, you don't need to include your spouse since they don't have a social. The only reason they're telling you that is because they are not an IRS acceptance agent that can do the ITIN. Okay. Or they don't want to do the ITIN because that means they will need to mail in your tax returns. Mhm. You see, that's why you go to a IRS acceptance agent because then they don't need to do all the extra stuff, right? There's stuff that they can bypass because they are an IRS acceptance agent for the ITIN. But if you go to a tax preparer that's not familiar with how the ITIN process works, why you need to file married, they will try to convince you, oh no, you can just file single. They don't have a social, so you don't really, and they don't have income, so you don't need to report that. Doesn't matter if they have a social, doesn't matter if they have income. Okay? Does not matter. You still have to include them. That just that's the IRS rules. That is the IRS rules. So if you're watching this and you're like, "Ooh, I made that mistake," go ahead and talk to a CPA, like enrolled agent, get that fixed, and you can, like I said, amend your tax returns. You can amend your tax returns. So go ahead and do that. All right. Before I got my citizenship, I made sure all my tax was okay for me and my family. You need to be clean in all aspects to not have issues with naturalization. Very true. And on your naturalization application, the N400 also asks you if you have filed your tax returns since you got your green card, which is a requirement. So if you are a permanent resident, and you are working in the US and you have a filing requirement and you choose not to file your taxes, you are not getting citizenship until you fix that. Okay. And if you owe the IRS, that's the other part. If you owe the IRS money and you go and file for citizenship and you do not have a payment plan with them, you have not paid off that amount, it is going to be a problem because the officer cannot approve you if you are telling them that you owe the IRS taxes. Okay. So, what I typically recommend in those situations where you may owe is see if you can get a payment plan. If you can get a payment plan and you can bring documentation of the payment plan and showing that you are making payment and you are, current with your payments as the payment plan requires, The officer can still approve you because you are taking steps to fix the problem. Now, if you owe like 10,000 and you're not doing anything about it, don't apply for citizenship. Don't do it because you will get denied on good moral character grounds. I'm telling you right now. Okay. My friend fears that if he files his taxes this year, it can cause him some troubles. He's waiting for 2026. So that's another thing. So I want to make myself very clear. If you are filing a marriage based green card application, you should be filing your taxes with your spouse, even though they don't have a social, right? Because you are already going to be giving USCIS all your information, right? All your spouse's information, all your information. So you might as well file your taxes properly. Now, if you are in the US without documentation, you don't have any means of getting the documentation, that's a different conversation you need to have than someone that's in the process of getting status. Okay. So it's really important that you kind of understand that. It's a different conversation to have. Um, if you are not in status and you have no way of getting status, like USCIS does not already have your information, ICE does not already have your information. Those are two different things, right? No one has your information. Nothing is, you may have to, think about the risk versus the reward on that. But there is a law that says if you're in the US and you earned income in the US, you need to file a tax return, right? So even though you may be worried about the immigration aspect of things, there's also you know, the IRS law aspect of things. So it's a balancing act, and a lot of people are doing those right now, especially with the agreement between the U.S. government, DHS, and ICE, um, and the IRS, right? That agreement, whatever it looks like, whatever it may be, we don't have all the details of what it is. So until we have all the details, a lot of people are scared, and I don't blame you for being scared. Hi, Zach. Please do green card holders have to register? Nope, you are already registered. Okay, green card holders are already registered. If you have a work permit, you are already registered. Okay, and even if that work permit has expired, you are already registered. So, no, green card holders do not need to take any other steps other than have your green card with you. I am I-485 applicant. My wife filed as separate on last 6 months and filed married filing separate. What to do now? Oh, and you filed married filing separately. So she, so I understand if you have children, I understand the want to do head of household instead of married filing separately because there's certain credits that you don't get if you file separately. I know there is. But but you need to decide what is more important, right? Is it getting the refund or getting the green card, right? Is it getting the additional money on your taxes or is it getting your green card? So in this case, you can amend or she can amend to go separate or you two can amend to go joint. But it's either filing separately or filing jointly. You can't have it kind of both ways. Okay. All right. Great questions, guys. Again, you want to amend with an accountant or a like someone that understands the rules. Okay. Is it possible to get a social security number if you are here in the US with a visa? It depends the type of visa. Okay. So if you are here on a B1, B2 visa, no. Okay. B1, B2 visa is for visit. You are here to vacation and go back home. You are not here to work. So you are not getting a social security number. Okay. However, if you have an H-1B, you're going to get a social security number. If you are here on a H-2B, H-2A, like all those employment based visas, yes, you can get a social security number. If you are a student and you are going to be working on campus, you can get a social security number. If you're a student and you're going to be on OPT, you can get a social security number. However, if you are here strictly for a visit on a B1, B2 visa, you are not getting a social security number. Okay. So I know this that used to be different. I will say this. That used to be different like 30 years ago, 40 years ago. The Social Security Administration was not as tightly connected to the immigration part of things. So that also makes a huge difference, okay? Because it wasn't so connected, you're able to get a social security number back then without having the ability to work in the US or live in the US even. But that all changed when they connected the two, where now, before you can get a social security card, a social security number, that administration reaches out to the Department of Homeland Security to see what your status is. And based on what they say, will determine whether you actually get the social. So what about K1, K2 for fiance? Technically, yes, right? But you also wouldn't have ability to work, but you can get a social if you're within your 90 days. Okay. So within the 90 days of the person coming in, because that only lasts for 90 days. So within that 90 days, you can apply for the social, but then you're not able to work either. But you can at least have the social if you want. Does someone that came into the US with a visiting visa and have overstayed have to register? No, because they came in with a visa. So a visa, basically, according to USCIS, I always have to, according to USCIS, the last time I checked, they said that if you apply for a visa, you do not have to register because that counts as registration, even if, here's the crazy part, even if that visa was not approved. Because for you to get to the final stage of having an interview and then being approved or denied the visa, you are you are probably doing a medical, you are probably doing biometrics, right? You're doing all these things to even get to the interview. So they already registered you into their system through the Department of State. So if you apply for a visa and were denied, or if you came in with a visa, you are considered registered, so you don't have to go through the registration process. Okay. Oh, just the guy. Yep. I'm glad that makes sense. Yes. Within the 90 days, you are able to get a social if you came in on a K1 or K2. After that, they wouldn't, because when they run it with DHS, it's going to show that you do not have a current status unless you already have a green card application pending, and then you can kind of get it through that. Why are VAWA receipts being delayed? It's taking a long time. Yes, it is. It's taking months. Before it was like 4 weeks, you can expect to get the receipts, but now it's taken months to get a receipt for VAWA. So it's nothing to do with you. It's just their process. They did update how they process the VAWA applications, which was supposed to make it, supposed to make it easier to get your receipt, but it's only made the process longer. Okay. So before, you were able to send your application directly to Vermont, then they changed it that you have to send it to a specific service center, to a specific lockbox, to now process the VAWA and then send it to where it needs to go. that has only delayed the receipts even more. So it's completely normal. It's taking months. It's it's horrible. It's horrible. But just because the receipt is taking a long time doesn't mean that they haven't received it or that they are not processing it. And that's why we send every single application to USCIS with tracking because we can track and make sure that it got there. At least we have the like peace of mind that it got there. If they reject it, that's a different issue because if it's taking them months to send you the receipt, it's probably going to take them months to reject it and for it to get back to you. And now you have to fix whatever the rejection reason is and have to send it back. Hopefully you are not beyond your, deadline to file, depending on if it's like you're divorced or whatever the reason. Um, but it does make it harder to properly plan and um, do all of that. Is the new administration causing any delays in VAWA processing for cases involving psychological and emotional abuse? What documents are most important if there's no police report? Okay, I'll take it. Those are two questions in one. Is the new administration causing any delays in VAWA processing? Yes, they are. They sure are. So VAWA applications, you know what? Let me reverse that. No, they are not. This rule that I'm about to talk about came out before the new administration, unfortunately. So VAWA applications are now being scheduled for interviews. Before, VAWA applications were not being scheduled for interviews. A VAWA application can be approved without an interview, but there's a new thing that started last end of last year where VAWA applications were now being interviewed. The VAWA itself, not even the green card, the VAWA itself is now being interviewed before the case is approved or denied. Here's the thing, according to that rule, according to that new memo that was out last year, it seemed like that was only for cases where you're filing the VAWA application and the green card application at the same time. In those cases, they are scheduling select few for interviews, and that's going to delay the process because do you know how long it takes them to get to a marriage-based case for an interview? Talk less of also now adding VAWA cases on top of all the other cases the offices have to, interview. And we are also getting less officers because they're firing people. So more interviews, less officers means delays. Okay. Unfortunately, that's going to mean. Okay. And then for the second part of your question, for cases involving psychological and emotional abuse, what documents are most important if there's no police report? So most of my cases, there is no police report. I've had quite a few where they are, but most of the cases there's no police report because the person is too scared to call the cops, first of all, right? And they feel that they will be the ones in trouble because they're the ones that do not have status. So they never call the police. Now, how can you show psychological and emotional abuse? Psychological evaluations are a great way. If you are consistently seeing a therapist, your therapist notes can be helpful. And then also statements from witnesses, detailed declarations are really good because it shows like exactly in your own words what has happened, how what was said, things like that. And then if the abuser is bold enough to text or send voice memos, which trust me we have seen, and I have had to kind of breathe through some of the things that I have seen abusers send or voice memos that I had to listen to. That was just hard to listen to. But those are evidence as well. So text messages, you can download those. There's apps to, if it's direct text messages, there's apps that help you, download those. And then for voice memos, the only thing with voice memos, they need to be transcribed. USCIS is now going to take, a digital file of it. They're going to want a transcript of what was said in the voice memo. But all those things are ways to prove the abuse. Okay. So, police report is not the end all be all. Okay. The police report helps if there's actual physical abuse, right? Physical abuse is typically when people end up calling the police, not for psychological or emotional abuse, not even financial abuse. People don't call the police for. So, all those things matter. So the more documentation you have to show the abuse, the better. And it does not have to be police reports. Like we have a whole checklist of things that it could be that you can include. And also understanding that psychological and emotional abuse is not the only thing beyond physical abuse. Okay. And typically we go through like a whole range of things with people that they may not even consider abuse, but according to psychologists, are abuse. So that's why the psychological evaluation is really important, to have a professional talk to you and actually write a report detailing what they believe you have suffered based on their questions to you, their observations of you, things like that. Is a parent of a U.S. Armed Forces member can be deported? Yes. Anyone in the U.S. can be deported. Even people that have been in the military can be deported. Um, and that's something people are so surprised about. But there's, former former military members that actually served in the armed forces that were deported from the US. So if they can be deported, then yes, the parents can definitely be deported. Um, on the flip side, if the parent is in the US without inspection, they entered, they didn't have a visa, they didn't get paroled in, but their child is in the US military, the child can do something called parole in place for them. So, military parole in place for the parents. If that is approved, then the parent now has legal status. Let me rephrase that. Not legal status, but legal entry. So now they have a parole and they can use that parole to adjust their status. Okay. So the military parole in place will take someone that entered without any documentation, any inspection, take them from that status and having to need a waiver to leave the US and go to an interview outside of the US, to now being able to have parole. And then that child, if they're already over the age of 21, can file for them to get their green card in the US without having to leave, without needing a waiver for their overstay in the US. Okay. Just like yes. Even even veterans can be deported if they are not US citizens. And that's why I tell people all the time, check if you qualify for citizenship, okay? Because that is the place where you will be safe, right? That's the safest spot in the US, is to be a US citizen. Like, if you have been paying attention, we have had US citizens detained by ICE, even deported by ICE. But guess what? Because they're US citizens, it's quite easy to get them out of ICE custody or to get them brought back to the US. But if you do not have citizenship, they can play games with that. Okay. So if you qualify for citizenship and you meet all the requirements and you do not have negative immigration or criminal history, you may want to and of course you want to actually be a US citizen. I should mention that too. Um, and you want to be a US citizen, then go ahead and do that, because that's going to be the safest option. And for people in the military that do not go and apply for citizenship, confuses me because once you enter the military, you basically immediately qualify for citizenship, right? You have to be a green card holder to enter the military. Let's start there. You do have to be a green card holder to enter the military. But once you are a green card holder, you can adjust. You can go straight to citizenship once you finish. I believe once you finish basic training, you can go ahead and apply for citizenship. And that, oh my goodness, y'all are about to get me into a rabbit hole. But that also applies if you have a conditional green card. So if you have a 2-year green card that you need to apply for the conditions to be removed, but you join the military like a month after getting your 2-year green card, you finish your basic training, you meet other military requirements, you can go ahead and apply for citizenship and skip the 2-year removal of conditions and all of that and go straight to citizenship. So that's just something else that I always want to talk about when I talk about military because there's just that benefit of being able to apply for citizenship right away and not having to wait and not having to apply for removal of conditions and all of those things. Okay. Um, let me just make sure. If your adult child is a reserve, so it's going to depend on their actual like position, right? I believe they have to be like active duty. I have to get back to you on that. But there's a specific thing that at a minimum they have to be. I don't know if the reserves um, will meet that requirement. Okay. I don't know if the reserves will meet that requirement, but I will get back to you on that and probably do like a quick thing on that. All right. Just a guy, I could not agree with you more. I could not. That is one of the biggest shames that I see with immigration is the amount of military members that have to fight to remain in the U.S. or that their family have to fight to remain in the U.S. It is insane. It is insane, but it is part. U.S. immigration law is not as friendly as people think it is. I know in other countries, people will be like, "Oh, immigrating to the U.S. is so easy," but it really isn't. As someone that have been doing this for 10 years, doing immigration for 10 years, being a lawyer for 10 years, I can tell you, it is not easy, especially when I have to make that phone call and let someone know, "Oh, I'm sorry," even though you have all these things going for you. There's nothing you qualify for. Okay. Those conversations are hard. Or having to tell someone, oh, even though you're in the military and you're trying to apply for your citizenship because of X, Y, and Z, it's not going to work. Or, oh, you want to file for family, but because of X, Y, and Z, it's not going to work. Whether you've been in the military or not, it doesn't fix everything. But yeah, US immigration it's hard. It's hard. And seeing people struggle for years to be with their family to just get some form of status. And then they finally get that status and it's then ripped away from them without warning is whew, it's whiplash. Right now, I feel like we're having some immigration whiplash and everyone is just scared, understandably scared. But um, if I can leave you with anything, it's you can still apply for green card, you can still apply for citizenship, you can still do all of those things. It may take longer, they may give you a harder time, but if you qualify for it, they're gonna approve it. Okay. If you qualify for it and you meet all the requirements, they're gonna approve it. It's just how long is it going to take? What is the process? All of that is the hard part that we have to deal with right now. But just know USCIS is still approving cases. The embassy is still interviewing people. They are still giving out visas, right? That has not changed, at least not yet. And apparently, no one is currently banned from applying for a visa to the US. So think about that part too, right? We don't have a list of countries that are banned. I will always choose to look at the positives. So I hope you join me on the positives, thing today, which is there's no country that's currently banned from applying for a visa to the US. That may change, right? But as of right now, we can still apply. Things are still happening. The people having the hardest time, unfortunately, are people that don't really have a way of getting permanent residence in the US. Okay. Temporary visa holders are going to have the hardest time. And people that entered without inspection, again, if they do not have a way of getting permanent residence in the US, are going to have the hardest time with this administration, at least from what we have seen so far. And then everyone else is just, unfortunately, the rest of us are collateral damage in the midst of enforcement. Okay. And until all of that is, until they start caring about the rest of us too and not sweeping everyone up in their raids and not really caring if someone is a US citizen or permanent resident or all of that. Um, we'll keep fighting, right? That's all we can really do. We'll keep fighting, we'll keep moving forward, and hopefully one day um, we will get back to a normal US immigration, whatever that would even be in the future. But hopefully things stabilize and um, the craziness stops. But until then, we just keep fighting. All right. Okay. So thank you all so much for joining me. If you have questions, put it in the comments. Even if you're watching this later on, ask me questions. That's literally what these lives are all about, is answering your questions, keeping you updated. And if you are still here and you have not liked this video, please go ahead and like it. It just lets other people know that this is a video that they probably should watch too. Okay. What is the difference between criminal offenses and convictions? And which one is worse to make someone deportable, offenses or convictions? Oh, that is a great question. Yes. So there's a huge difference between the two. So it's the difference between being charged with a crime and being found guilty of a crime. Right? That's the difference. So someone can be charged with a crime and then the charges are dropped, right? A conviction is you were found guilty or you admitted to the crime. So that's something also that's different with immigration versus criminal court. So for criminal court, a criminal offense is like being charged with something. A conviction is being found guilty or pleading guilty to something, right? For immigration, it is being charged with a crime and then either admitting sufficient facts, right? Basically saying to the court, well, yeah, I may have done that or I did that, but please give me probation. And the court's like, okay, fine. You admitted that you did it, but we're still gonna give you probation. That is a conviction for immigration purposes. Okay. So even though it's probation, and for criminal court, probation is not considered a conviction. But for immigration world, it is considered a conviction. Okay. So just the guy, yes, I always say I'm leaving. I always say I'm leaving. And then someone asks a question and I just can't leave when someone has a question and is here looking for an answer. Okay. Um, So that's really important distinction there. A conviction is 10 times worse than a charge. So being charged with a crime and being convicted with a crime. So being charged with a crime itself will not make you inadmissible or deportable. Okay, being convicted will. Now, the Laken-Riley Act kind of changed that a little bit for certain crimes where being charged alone can make you subject to mandatory detention, where while the court case is still going on, while you're not convicted, you can end up actually being in immigration detention until they figure out what's going on with the criminal court. Are you convicted or not? Right. So that's something that is, going to affect people where they are charged with those crimes under the Laken-Riley Act. But everyone else, conviction is always worse than the charge itself. Okay. Is it possible to be inadmissible but not deportable and vice versa? Yes. Yes, it is. It really is. So I'll give you like an easy example, just an easy one, because we can go down a rabbit hole of this. But an easy example is that someone that is in the US, so they overstayed a visa, they are deportable. Does not, right? They are deportable. But if they are married to a US citizen, they are not inadmissible. Okay. So they are deportable, but they're not inadmissible, which means they can apply for a green card based on that US citizen spouse and get a green card. But they could also, before that happens, could have ended up in deportation proceedings because they overstayed their visa. So that's where you can be deportable but not inadmissible, or inadmissible but not deportable, right? It's really it's really just that. And then for crimes, I'll give you a quick one. If you have a violation of a restraining order, right? So you have a restraining order, you violate the restraining order, you are not inadmissible for the violation of a restraining order. However, you are deportable for that same crime, right? So that same crime makes you deportable, but it does not make you inadmissible. So that's why we really always need to look at the crime, the charging documents, the disposition before we make a decision of whether the person is inadmissible or whether they're deportable or whether they're both. We need to make that assessment before anything moves forward. But yeah, thank you so much for that question. What if I have a charge of misdemeanor class 4? If I go back to my home country with a 601A approved, should I apply for a 601? It depends, right? It depends on if that crime makes you inadmissible. It depends. If the crime makes you inadmissible, then you would go to your interview. The officer will make the decision that it makes you inadmissible. Then you can apply for the 601 waiver. Okay. So that's how that would work. Is you need to know if it will make you inadmissible, if that's going to be something that the embassy is going to bring up. And if it's something the embassy is going to bring up, then you want to make sure that you're ready for applying for that 601 waiver, because it really, that's where it really matters, right? But you won't be able to apply for it ahead of time. So you have to go to that interview. The officer has to make that determination and say, yes, this makes you inadmissible. And then you go ahead and apply for the waiver. But you can only apply for the waiver after the interview. Okay. Public intoxication was the charge. Never went to court, just paid the fee. Typically, no. Typically, that, yeah, typically those specific charges do not lead to someone being inadmissible or deportable unless there's like more to it, right? Unless they were a DUI where someone actually got hurt, then they would those things will apply. All right. All right. Thank y'all so much. Now I'm really gonna go. I will see you all next time. And hopefully, you come with your questions. You stay up to date on everything that's going on. I do put out a video every Thursday, and then these ones on Fridays. And the one this Tuesday is going to be on registration. So if you have questions about that, make sure you watch that video on Tuesday. Okay. Bye, guys.